Bonjour tout le monde. Bienvenue. Merci d'être présent en si grand nombre après un keynote speech qui était très intéressant, n'est-ce pas? Qui donne un peu d'espoir. Hein? Il faut continuer de s'accrocher à l'état de droit. Nous avons annoncé un panel bilingue. Alors, ce n'est pas le cas. Nos panélistes vont parler en anglais. Donc, c'est pour ça que j'ouvre la discussion en français. Donc, je suis Fannie Lafontaine, prof à la Faculté de droit de l'Université Laval. Je suis aussi directrice du partenariat canadien sur la justice internationale, who sponsors this panel, so the Canadian Partnership on International Justice, which two of our colleagues here are members, and Kylie is a close ally. We'll talk about it later. So the partnership has been quite involved on the issue of the Rohingya and accountability issues, which of course means justice in terms of criminal justice, but which is broader as well, including how to collect evidence, how to talk about broader human rights violations and just crimes under international law. What does justice mean in context of movement of population, of repatriation? So we've been very involved at different levels, which I think will be touched upon when we talk about it. So we're very happy to have our three wonderful experts here to discuss different but interconnected issues about accountability and the role of international criminal law in this case and the International Criminal Court with this huge crisis that the Rohingya are facing. And so we will have three speakers who are here. First, in this order. First is Carl Matthews. He's the director of the Montreal Institut for Genocide Studies and Human Rights. And he's been very involved in the Rohingya crisis with his colleagues, calling on Canada to do more on different levels. And he will have a talk which I'll let him introduce about the use of social media in the lead up to the gross human rights violation or in the creation, or you'll explain it better than I do, particularly in my second language. Then we'll have Payam Akhavan, who's a professor of law at McGill University, among other things, because he's very involved in different levels in international institutions, arbitration, and tribunals, including the International Court of Justice. I'm making a very short bio. You have the full bios on the website and in your program. And he's also been very involved in the Rohingya crisis, visiting Bangladesh camps. He'll talk about this, and his talk is going to be a little more precise on the ICC, International Criminal Court jurisdiction. And then we have Valerie Oosterveld, who's one of the greatest world experts on gender violence, sexual and gender-based violence and accountability, and who's used to be dean or an assistant dean as well, right? Assistant dean?
Associate dean.
Associate dean, we say associate. And she's part of the partnership. And so we're very happy to have you, and she'll talk about accountability for sexual and gender-based violence. So we have about 15 minutes each, so we allow for a lot of interaction between the panelists and discussion with you. Welcome, and without further ado, Carl.
Should I stand up there? Or?
As you wish, it's really up to you.
I always think better when I'm standing. I don't know why, but I do. It's great to be here and with the distinguished speakers on the panel and with Fannie. I've been working on the Rohingya issue for the past few years, predominantly related to the responsibility to protect, interdicting mass atrocity crimes, as well as humanitarian aid and hate speech and emerging tech. And so it's going to become abundantly clear that I'm not a law scholar. I'm not trained as a lawyer, but I'm very privileged to be here in front of you to share my ideas because they intersect with the field of law and international justice. So my talk today is called Digital Hate, How Social Media Was Used to Dehumanize the Rohingya. I'm going to start off, though, give a bit of a more brief background about the Rohingya crisis, how it started, or the history of this minority and how they're miscommunicated, and then how social media was used really to sow the seeds of hate and societal anger and violence towards the Rohingya. So let's see if this thing works, the first start. Wonderful. So, I didn't do it on mine. So eternal persecution. The Rohingya, before this crisis, have a history of being targeted, of forced displacement, 5 or 6 major waves of forced displacement back into Bangladesh and coming back over the past century. We've had in 1982 the Burmese government at the time, the Myanmar authorities, revoked the citizenship, creating an entire stateless class of people. They're a different ethnicity from the major Buddhist majority. They're also Muslim, so there's a tension there, sectarian between the Buddhist and the Muslim populations. And then before this crisis, there was a total limit on freedom of movement. People were not allowed to travel or move across the country. They need to get government's approval to marry someone, which is also very prohibitive in cost. So there are all these things put in place by the central authorities to make life miserable for the Rohingya. But then we really saw, at this next stage, we saw communal tensions in 2012, where many of the Rohingya in Rakhine State, which borders Bangladesh, were basically forced into IDP, kind of almost like IDP camps, but they weren't allowed to leave. Horrible living. And then what we saw is in August of 2017, there was an attack by a militant, supposedly a militant group of the Rohingya that attacked a border post, 9 to 12 police officers killed. It was never verified by any independent authorities, but that led to this crackdown. Within a matter of days, we had a mass movement of now over 700,000 people that fled into Bangladesh. They've given eyewitness testimonies of sexual violence, civilians being murdered, crops being burnt, entire villages being destroyed. Amnesty International and Human Rights Watch put up amazing satellite photos of villages during the monsoon season by you, of which entire villages on one side of a valley were all burnt. They were all Rohingya, and another village wasn't touched. So the authorities that said that they lit their own homes on fire when they already left is a little hard to believe. And this has been, I think, a really hot button issue in Canada for a couple of reasons. Well, first of all, is that the Nobel Prize winner, laureate Aung San Suu Kyi, the political leader of Myanmar, is an honorary Canadian citizen. So this really put a lot of pressure on the Canadian government and also a lot of Canadian human rights groups to demand that she have her citizenship revoked. So there was a lot of focus on this. Prime Minister Trudeau appointed Bob Rae to be the special envoy. First time we had a prime minister named a high-level person to an ongoing atrocity to try to seek a political solution. And then we had just recently, a few weeks ago, we had the Canadian Parliament not just recognize the genocide, but also revoke her citizenship. So there's been measures that Canada's been taking that's been really in the media here, which I find quite interesting. There you go, here. So now I get to more about the tech side. Famous Canadian philosopher of communications theory, Marshall McLuhan, once said, all wars have been fought by the latest technology available in any culture. And I think that's quite interesting what we're coming to understand, people in the human rights field, that the advent of digital media, of social media, has changed conflicts and has also changed the way that people can incite people to commit violent acts, leading genocide. We know there's a duality of social media. Emerging technologies can be used both positively and negatively. There's a practical application of social media for the protection of human rights. The International Bar Association has developed something called Eyewitness, an app that you can track atrocities and use it for prosecution. But we also now see in the case of the Rohingya, we see the nefarious use of social media for hate speech and also inciting violence against minority groups. Facebook is being kind of on the spotlight here because Facebook is the internet in Myanmar. There's no other social media. Facebook is the one, so they've been under enormous pressure if you've been following the news on this. Increasingly, they're being brought to task for not doing enough. And I think in this case, where I'm talking about social media and how it intersects with international law, I point to point C here of the 1948 Genocide Convention that talks about direct and public incitement to commit genocide. I think that's been well documented, and we have so much digital evidence of authorities in Myanmar who have done so. And for those of you who followed other atrocities or genocides in the last 20, 30 years, the media has been a major part of this. We had the Rwandan genocide, in which radio was really the primary tool that governments used to incite violence towards a minority, to dehumanize the group. You know, one of the 8 stages of genocide, one is to dehumanize and classification. So the social media revolution kind of changes that. And this is what was one graph I wanted to show you, is that if you look at, let's say, Radio Milkal in Rwanda that had, maybe 300,000-400,000 listeners, or maybe 2 million, now we have platforms like Facebook that have over 2 billion users. So if you get on some of these platforms as an individual, you can actually really broadcast your hate much further and wider than traditional media platforms. Here's a quote from Montreal. I think it showcases about the opportunities and challenges of documenting mass atrocities using social media. Montreal, I don't know if he lived in Mosul, and he was a historian who documented the crimes committed by ISIS against civilians and destruction of cultural property. And he just showcases that how it can be used for positive. And I also say a positive thing is that the ICC has recently prosecuted a Libyan national using only digital evidence for killing soldiers in Libya. And then we also have cases of where more human rights activists are using social media, particularly YouTube, to document videos of atrocities for eventual prosecution, but it goes much further than that. And here's I like this from a Rohingya rights blogger who says, the history of modern warfare has shown us that new weapons, biological, chemical, and now, I suspect, digital, are tested on vulnerable communities, the poor, the forgotten, the powerless. If we can understand the weapon, maybe we can use the knowledge to protect some of the world's most vulnerable people. This is a lesson that we're learning of how to... Oops, sorry about that. I want to go back. So this is... Yeah, so there's been a lot of bad actors. This man, Ashin Wiratu, Time Magazine, he's been one of the most prolific spewing hate online. He was actually kicked off Facebook a few years ago, moved to YouTube, didn't have a great following, but he has been in the news and whipping up sectarian tension between Buddhists and Muslims. There are faces to these people that we now know. This is an example of some of the posts that have been taken on Facebook. One says, "May the terrorist dog Kalars fall fast and die horrible deaths." This has been that Kalar is a pejorative term for Muslims in Myanmar. There's been so much of this stuff online that really created not just government hate but also societal hate, particularly in Rakhine State. More interesting, though, that while there have been 2 journalists imprisoned by the Myanmar authorities for uncovering atrocities. Oh, sorry, right here. BuzzFeed News, for example, analyzed Facebook posts, 4,000 in total, of politicians in Rakhine State where most of the atrocities took place. And they found between March 2017 and February 2018 that over 10% of all the posts by politicians qualified as hate speech according to Facebook's official policy. Sorry, my screen here is not working. It's frozen. Anyway, so Mark Zuckerberg has been on the receiving end of this. He's realized that it's a real issue. Yeah, I'll try to see. I can kind of stand up here and look at the screen. But Facebook has made numerous errors in Myanmar. When they started operations, they didn't actually have any Burmese speakers to review content. They were only English speakers. It doesn't work in a country like that. They then, I think 2 years ago, they had 2 content reviewers in which there are 20 million users using Facebook. So Facebook has not taken this problem. They've tried to use artificial intelligence to try to detect hate speech, but they couldn't detect the cultural aspects of the Burmese language and culture. They could not pick up the memes or the videos that contained hate speech. And they've also outsourced. They've outsourced their efforts to private sector companies in other parts of the world that are not tuned into what is going on. So they've made a lot of mistakes. And the question is, what responsibility does Facebook have in this? I mean, from a legal perspective, which I'm not an expert, but if platforms are being used to incite and commit violence, I think we have to ask those questions. Traditional media doesn't get away with saying, well, whatever someone puts in our newspapers, we're not responsible. But social media companies say they're not publishers. They're not a media company. They're social networks. And so they seem to get in between to get out of a lot of the responsibilities that traditional media can't get away with. So negative use of social media, it's the first time ever, for example, that the United Nations has called out a social media company for having some role in atrocities. Marzuki Darusman, chairman of the UN Independent International Fact-Finding Mission on Myanmar, says, quote, "It has substantially, Facebook, contributed to the level of acrimony and dissension and conflict, if you will, within the public. Hate speech is certainly, of course, a part of that. As far as the Myanmar situation is concerned, social media is Facebook, and Facebook is social media." And we know that misinformation, fabricated stories and videos of Buddhist victims of Rohingya attacks, incitement to violence and hate speech against a Muslim minority group. There's lots of derogatory pages. UN Myanmar investigator Young Hee Lee, South Korean academic, quote, said it was used to convey public messages, but we know that the ultra-nationalist Buddhists have their own Facebooks and are really inciting a lot of violence and a lot of hatred against Rohingya, or the ethnic minority. So this is being picked up by the UN, first time ever. I haven't heard of that in any other modern conflicts. So here's just, I just want to show you a visual of one of the posts. This is the same Buddhist monk who says, "You can be full of kindness and love, but you cannot sleep next to a mad dog. If we are weak, our land will become Muslim." So kind of inciting this, telling his followers that there's this great civilizational clash of civilizations going forth, and that they have a responsibility to abandon human rights and actually commit violence. We also have another graph on the side that shows after the start of the forces placed in the Rohingya, we see a massive amount of data of anti-Rohingya posts on social media platforms just going through the roof, and many of them were bots. And there's another smaller one there that I can't even read on my screen, so I'm sorry, I don't think you can read it either. But there's ample evidence. There's so much evidence of these platforms, Facebook, being used by particularly the military. There's evidence now that the Myanmar military has been trained by the Russians, and they're using some of the same techniques to spread confusion and break apart social cohesion in societies, even Western societies. That's what the Myanmar authorities were doing. I've got 2 minutes left, so this will be very quick. I've got only 2 slides, so this is good. But I just say there's a problem with Facebook generally. Facebook's most consequential impact may be in amplifying the universal tendency towards tribalism. Posts dividing the world in us versus them rise naturally, taping into users' desire to belong. The last keynote speech on the US kind of touched upon some of this, if some of you can connect that. Facebook rewards engagement, delivering a dopamine boost when users accrue likes and responses. Its algorithms unintentionally privilege negativity. Social media allows anyone with a smartphone the ability to broadcast. And Facebook officials ignored warnings of potentials for violence. They did not hire moderators or establish local offices. So, and all their community standards were violated, but they didn't take most of the posts down. So this is a really challenge that we have to think through. So I'm going to just have some closing thoughts that I've thought about this, because my institute does a lot of work on tech and human rights, but I think that governments must play a role by streamlining policies and engaging experts with knowledge of how social media and atrocity prevention are linked. Racist and abusive language against minority groups online can lead to real-world violence, so we need real-world policies to deal with this. Innovative civil society organizations which deal with these issues need support and are willing to engage in monitoring hate speech and incitement to violence in real time. Prevention, extremist cheerleaders and supporters have to be tracked, especially when they're government officials or the head of the military. They need to be identified and exposed so their messaging can be disrupted. And last point I'd say is that more private sector cooperation and corporate social responsibility is needed. Google, Facebook, and Twitter have to police their platforms to ensure they're not used to foment atrocities. And I think this is an important lesson we're seeing now, not just Myanmar, but in South Sudan, in Sri Lanka, even in the United States. We're seeing this, we're seeing deep tensions arising because of the misuse of social media, and I think we need to do something about it. Thank you.
Good afternoon. Thank you very much to my dear friend and colleague Fannie for organizing this panel, and to Kyle and Valerie, who are very dear colleagues who've made very important contributions to this cause. I'll begin by disclosing that I'm counsel to the government of Bangladesh in the International Criminal Court proceedings relating to the Rohingya, but that anything that I say today is in my personal capacity. And I say this in particular because the submissions of the government of Bangladesh to the court have been and remain confidential. I'll begin by saying that this panel, and in particular the discussion of my colleague Kyle, is a reminder that we have failed yet again to prevent genocide, which, unlike earthquakes and tsunamis, is not a God-given disaster. It takes tremendous effort to incite hatred, to mobilize the Tatmadaw military in a strategic, concerted campaign lasting over several months to systematically destroy villages and terrorize some 1 million Rohingya into leaving the country. And I say this because I began my career in Bosnia-Herzegovina, where I served as a UN human rights officer during the days when ethnic cleansing became part of her lexicon, Srebrenica genocide, and I served in Rwanda. And I remember exactly the idea of lessons learned and contrition for what we should have done, what we could have done, how we had all the early warning signs but chose not to do anything. And the measure of success in the human rights world is what does not happen, what never becomes headline news, what never makes it to the agenda of the Security Council, what never becomes the topic of a CCIL panel. So the world has failed once again, and I say this because just a few months ago I had met Kofi Annan in Oxford, who sadly very quickly demised, not because he met me, but because of other complications that he had with his health. But it reminded me exactly of his legacy, which was to establish the Office of the Special Advisor for Prevention of Genocide. Juan Mendez, great Argentinian human rights lawyer, took that office. And I remember those days when there was so much promise that we have learned lessons, that we are going to take action. So the point is that by the time we speak about genocide, it is already too late. And there is no punishment that is adequate for genocide. To quote Hannah Arendt, these crimes explode the limits of the law. And we have to be very humble in understanding the grim reality of the survivors when we promise them that we're going to try and pursue accountability. But some justice is better than no justice at all. I was in Kutupalong in June of this year, speaking to many of the survivors, and Kutupalong 2 years ago was a refuge where wild elephants roamed about. Today it is the biggest refugee camp in the world, where some 700,000 deeply traumatized people live in what can only be described as an ocean of misery. And it's very easy to forget what lies behind these abstractions that we call crimes against humanity and genocide. And I think being in that camp reminded me of why we must do whatever we can, however inadequate it may be, to pursue some measure of justice. I met a 9-year-old boy with missing limbs. I met a 12-year-old who had a huge bullet wound in his stomach, a 5-year-old with a machete wound on his skull. I met a group of women who, in the middle of Ramadan, of course, being traditional Muslims, were wearing their niqabs, and when I entered the room, they stood up one by one and walked up to me and pulled off their head covering so I could see their face. And they told me the most harrowing stories, and I realized that most of them were in the 3rd trimester of their pregnancies, and their husbands had been killed. And I put 2 and 2 together and realized that most of them, if not all of them, had been made pregnant as a result of rape. And as we speak today, those women are still in Kutupalong now, probably with infants of a few months. One of them told me how her infant was thrown into the fire by the Tatmadaw. So these are the grim realities of the intense, unspeakable human suffering that lays behind this abstract thing that we call ethnic cleansing and genocide. And what was astonishing is that every one of those people wanted their story to be told. They wanted their suffering to be recognized and vindicated. It made me realize that it matters, justice matters. Even as inadequate as it may be, as I will explain, it is absolutely essential that we do what we can. So what are the options for accountability? Well, we have the International Criminal Court in The Hague, which is really the only means of bringing some measure of accountability. We have the establishment of the General Assembly investigative mechanism and fact-finding missions, but ultimately, individual criminal responsibility can only be achieved through the International Criminal Court. The problem, of course, is that a Chapter 7 referral is virtually impossible because of the certainty of at least one, if not two, vetoes. So some time ago, those who believe in creative lawyering began to explore the prospect of establishing the jurisdiction of the court by virtue of the fact that while Myanmar is not a state party, Bangladesh is. And of course, to the extent that crimes were committed on the territory of Bangladesh, the court would have jurisdiction. And the theory was that the crime of deportation, while commenced on the territory of Myanmar, is completed on the territory of Bangladesh. And understandably, the prosecutor, who is already stretched very thin, with very limited resources, did not want to embark on an investigation without clarifying that the court did in fact have jurisdiction. So in April of this year, there was a request by the prosecutor in the form of an advisory opinion under Article 19.3 of the ICC statute, the first time really where a pretrial chamber is asked to deliver what is in effect an advisory opinion. And the question put to the pretrial chamber was whether the court has jurisdiction over the crime of deportation. And the court issued invitations to both Bangladesh and Myanmar to submit their observations. And there were a number of, I think a significant number of amicus briefs, one of which was the wonderful Partnership for International Criminal Justice, spearheaded by our great guru and leader right here, my dear friend Fannie. And I can say that the Canadian participation in this proceeding was quite important and quite significant. So Bangladesh made a confidential submission about which I can say nothing except that it was made. And then Myanmar was invited, and as I will explain, Myanmar refused to make a submission, but then, and this is highly significant, made a press statement that reads like a legal brief. And I'm quite sure it was not drafted by Myanmar officials, but they retained somewhere a scholar or practitioner of international criminal law to write what was quite a sophisticated brief challenging the jurisdiction of the court. So the matter was considered by the pretrial chamber, and on 6 September, the pretrial chamber ruled by 2 votes to 1. The one vote was a dissent not on the substance of the question of deportation, but on whether it was appropriate to use Article 19.3 to render an advisory opinion. But the court held not only that the ICC does have jurisdiction over the crime of deportation, but that the prosecutor should expedite the preliminary examination stage and move quickly towards an investigation, which sadly is a bit of wishful thinking, given the scarce resources, inefficiency, and I dare say the incompetence that we have witnessed in the International Criminal Court, which celebrates its 20th anniversary this year. And I say this because in order to expedite this process, one may have to think creatively about how to give the court the resources that it needs in order to ensure that we are not going to have a prolonged period before arrest warrants are issued. Now, the deportation theory is interesting both as a matter of law and as a matter of evidence. So the theory is that the crime of deportation, unlike the crime of forcible transfer, is only consummated upon the crossing of an international boundary. And I'm careful in choosing my words, and instead of saying crossing from one state to another, the crossing of an international boundary, because it is also possible that people are expelled onto the high seas, which is yet another mode of deportation. And if you look at the statute, the Charter of the International Military Tribunal and the statute of the Yugoslav and Rwanda tribunals, there is only a crime of deportation but no crime of forcible transfer, which in the jurisprudence of those institutions was introduced by way of this residual category of crimes against humanity called other inhumane acts. But the ICC statute, which I suppose was a state-of-the-art definition of Crimes Against Humanity, which was adopted in 1998, which had the benefit of the jurisprudence then of 4 or 5 years of the Yugoslav and Rwanda tribunals, joined deportation or forcible transfer in a single provision. And with respect to a court of general jurisdiction, as was the case with Yugoslavia or Rwanda, it really didn't matter as a matter of evidence whether you charged deportation or forcible transfer. So you always charged them in the alternative. And in the context of the former Yugoslavia, it was a complex issue because socialist Yugoslavia began as a single state and then disintegrated into separate independent states, and it wasn't always entirely clear at which point there was a crime of forcible transfer or deportation across what then became an international boundary. But in this case, it's absolutely crucial. And given the potential repercussions of the court now ruling that in any case where there's an intention to deport, the court has jurisdiction even if the state in which the deportation commences is not a state party, people are already saying, well, then we have jurisdiction in respect of Syria, where Chapter 7 referral was defeated twice by a Russian veto. And people are already saying, well, the Jordanian refugees are a basis for the jurisdiction of the court because Jordan is a state party. And my advice is, hang on a minute, it's not as simple as that, because when the sole basis for the court's jurisdiction is a crime of deportation, there has to be proof of the specific intent to deport, of the specific intent to expel people across an international boundary. And this is where my visit to Kutupalong was quite illuminating. And without entering into too many details, I think it is significant, going back to what Kyle was saying, that the propaganda of the Myanmar military, including all these bots and Facebook postings, is, first of all, not to use the word Rohingya. No such thing as the Rohingya exists. They are illegal Bengali immigrants who are actually being sent back to Bangladesh where they belong. That is the official position, which of course helps with respect to proving an intention to deport, because their intention is to send them back to the country to which they purportedly belong. But beyond that, it's quite remarkable to see some of the testimony of the survivors who speak about the Tatmadaw telling them that if you don't go to Bangladesh where you belong, you will be killed. But one of the remarkable things was to meet with members of the Bangladesh border guards, who in my view are heroes, a long time before the international relief agencies approached, because this mass exodus happened so quickly that it took some time before the UN agencies were able to be there on the ground. So one of the, as a sort of footnote here, is the remarkable generosity of the people of Bangladesh in receiving 1 million refugees in what is the most densely populated country in the world. So when these people were pouring across the border guards were helping them, of course, but the local farmers who are very poor came with all of their food and started distributing rice among the refugees. They put people up in their own home. It really puts to shame the kind of narcissism and xenophobia which we're witnessing in our prosperous part of the world. Discussion for another time. But the point is that many of the Bangladesh border guards had a weapon which is in the form of a cell phone. And they took remarkable photographs and videos, not only of the condition of those that were appearing, but also of the Myanmar military with loudspeakers basically pushing people across the border, and in a very direct way at what's called the zero line, which is a sort of no man's land between Myanmar and Bangladesh, specifically pushing people out across the border. And there is a no man's land between no person's land, excuse me, between Myanmar and Bangladesh, and many of the people congregated there because they didn't want to cross into Bangladesh. They didn't want to be refugees. They wanted to be IDPs, and they were specifically pushed out of there. So there's considerable amount of evidence, and one of the remarkable things is how people don't realize the significance of what they may just have innocently filmed. So I say this because the investigation is going to have to be very narrow, because the court will, with good reason, not want to expand the scope of deportation and see this as a very narrow exception. Just maybe a few quick thoughts before I finish. I think getting back to the fact that Myanmar issued a press statement, that the court's proceedings are already showing some signs of influencing, at least in a superficial way, the behavior of the authorities in Myanmar. So there are about 1 million refugees, 700,000 of whom crossed from 2016-17 onwards, about 300,000 from earlier waves of mass expulsion. When it comes to the question of the scope of crimes, deportation, of course, is just one crime among many, and I know that my colleague Valerie will be speaking about sexual violence and gender-based crimes. One of the good things about deportation is that it encompasses coercive acts which have resulted in forcible displacement. So that's one way of including the murder and sexual violence and other types of acts which otherwise would not fall within the scope of definition. But returning to Myanmar's position of issuing a press statement, which in effect is a legal brief. It's a submission to the court without accepting the court's invitation, which would then be seen as recognition of the court's jurisdiction. At the Shangri-La Summit in Singapore, which was taking place while I was at Kutupalong, the spokesman of Myanmar stood up and said, in quite a sophisticated way, well, crimes against humanity under the ICC statute requires state action or policy, and we are negotiating the repatriation of the Rohingya, those who are Myanmar nationals, of course. That's the big sort of qualifying part of the statement. So therefore, where is the state action or policy to deport, which is very interesting. General Maung Maung Soe, who was head of the Western Military Command in Rakhine State, who was in charge of the immediate execution of the ethnic cleansing campaign, also in June was dismissed from the military. Of course, he's not being punished. He's being given some sort of plum post elsewhere. But I think there are some signs that Myanmar is waking up to the reality that a few months down the road, arrest warrants may be issued and that this will exact a cost. Which brings me to the importance of rephrasing the term justice delayed is justice denied to justice delayed is justice delivered in the context of international criminal justice, something I learned when it took us 16 years to effect the arrest of Radovan Karadzic and Ratko Mladic, who, when I first arrived in The Hague, were untouchable, and the idea that they would one day be arrested was openly ridiculed as a fanciful dream of some naive human rights activists. But it happened, and the only way in which the ICC would actually have effect is if the international community makes the question of accountability front and center in its relations with Myanmar, because those who are in power today may not be in power tomorrow. And at some stage, if the cost is high enough, they may very well end up in The Hague. But even if they do not end up in The Hague, I think we have to bear in mind that there's still about 500,000 Rohingya in Myanmar. And there are already signs that the regime is thinking twice about mass expulsion and sadly is instead using the device of mass internment as a way of containing its Rohingya population. But one of the things I noticed is that the border fence, which used to be just a simple barbed wire fence, which allowed the 700,000 people to sort of cross into Bangladesh so easily, has now been fortified. So there's no way for people to return, but equally, there's no way to easily expel the 500,000 people that are there. So I think that deterrence is something we need to think about as well, that the threat of at least stigmatization, if not punishment, could perhaps ameliorate the condition of those people. And finally, I will end by saying that if there's only one thing we can do, which is to give symbolic justice as a measure of healing to those survivors in Kutupalong camp, that in itself will have made this effort worthwhile. So I'm going to stop there, and thank you very much once again to come.
So my topic today is to focus on accountability for sexual and gender-based violence that was directed against the Rohingya in Myanmar. You've heard already that sexual and gender-based violence was used on a massive and widespread scale in targeting the Rohingya in Myanmar. And I'm going to give you a snapshot of what the fact-finding mission has said about the sexual and gender-based violence, not to shock you, but to show that in every single situation in which sexual and gender-based violence takes place, which is most situations, the facts on the ground, while often similar, are also different. There are different markers of different conflicts. In this situation, the UN Independent International Fact-Finding Mission on Myanmar found that Rohingya women and girls aged 13 to 25 were specifically targeted. They were the main targets. They weren't the only targets, but they were the main targets, including pregnant women. Many of these victims who were targeted for sexual violence were then killed after being raped. Women and girls were raped with knives and sticks. They were also bitten on their necks, breasts, and thighs as a form of branding. Their breasts were also cut off or mutilated, and their genitals were mutilated. The gang rapes that took place often were in public on purpose so as to deepen the humiliation, to spread the terror further. And gang rapes often had 10 perpetrators. Sometimes there were up to 40 women and girls were reported to have been raped at once. 80% of all of the survivors interviewed in Bangladesh had been raped, gang raped, overwhelmingly by the Tatmadaw. There are also other types of sexual and gender-based violence, forced nudity and sexual humiliation, and sexual slavery, in which women and girls were abducted and held while they were being sexually violated. Men and boys also suffered sexual and gender-based violence, often in detention, and often they were raped or subjected to sexualized torture or sexual mutilation in order to secure information or to simply torture them. This information has not only been reported by the fact-finding mission, it's also been reported by many non-governmental organizations such as Amnesty International and humanitarian agencies. The fact-finding mission had found that while the massive mass sexual violence took place in August of 2017, sexual violence against the Rohingya, women and girls, men and boys, had been normalized for years prior to that the start of the mass expulsion, the most recent mass expulsion. So what has been going on? Well, there's been collection of information. It started almost immediately once humanitarian actors arrived on the ground in Bangladesh, and it's been going on for more than a year. So, for example, the UN fact-finding mission has obviously collected information on sexual and gender-based violence, but also the Special Representative of the Secretary General on Children and Armed Conflict, the Special Representative of the Secretary General on Sexual Violence in Conflict, and many, many different non-governmental organizations. And this collection of information is very important for humanitarian and other reasons, but it does raise an issue that we need to think about, that everyone who's interested in accountability needs to think about, because collection of information is different from the collection and preservation of evidence. And it's different in a few ways, but I'll give you an example. Collection of information involves speaking to victims and witnesses of sexual and gender-based violence in order to gain a solid picture of what has happened. Collection of evidence may require not speaking to victims of sexual and gender-based violence in order to not contravene the do no harm principle in evidence collection until the do no harm principle can be followed. So in other words, collection of information may occur right away. collection of evidence may require a delay in speaking to victims of sexual and gender-based violence until there are supports in place to ensure that the do no harm principle is not violated. So it's important for us to think about that when we think about accountability for sexual and gender-based violence in the Rohingya situation. Now, there are some people on the ground who are collecting evidence to the highest international standards, and they're doing this using best practices. So, for example, those who serve on the Justice Rapid Response UN Women roster of sexual and gender-based violence experts have already been part of the UN fact-finding mission and ensuring that the information/evidence that they're collecting does follow these best practices. That said, after the scope of the situation was being revealed in the media, there was a rush of organizations coming into Cox's Bazar and elsewhere collecting information, and not necessarily to the highest international levels of best practices. So there have been some steps apart from collection of information towards accountability. And the next one I wanted to mention is the creation of the independent mechanism. So the Human Rights Council in September recently adopted a resolution in order to create an independent mechanism along the lines of the independent mechanism created to collect information and evidence on Syria. And this independent mechanism is tasked with collecting, consolidating, preserving, and analyzing evidence of the most serious international crimes and violations of international law committed in Myanmar since 2011. So it goes back further than the 2017 expulsion. It goes back to the prior expulsion. This independent mechanism will prepare files in order to facilitate and expedite fair and independent criminal proceedings in accordance with international law standards. These proceedings may be in the national system, in a regional system, or an international court or tribunal, according to the Human Rights Council resolution. And the mechanism will make use of the fact-finding mission information and then turn that from information into evidence. The mechanism is directed to closely cooperate with the International Criminal Court. So why is this mechanism important for sexual and gender-based violence? Well, we know from past experience, past lessons learned from previous tribunals and previous atrocities, that recording evidence of sexual and gender-based violence as close as possible to the time in which it was committed is the best way to preserve detailed evidence of that type of violation. This information, though, this evidence needs to be collected in a gender-sensitive manner. The good news is that we already have positive lessons learned from the Syria independent mechanism, which is headed and with a deputy who have deep experience in the prosecution of sexual and gender-based violence in international criminal law and in bringing gender sensitivity to arranging all of the work that is done by the mechanism. And we also have the accountability that's possible through the International Criminal Court. Payam has explained the request brought by the prosecutor to seek clarity on whether or not the crime of deportation could be used, with Bangladesh being a state party to the Rome Statute. And I will just talk about the implications of the ruling of the pretrial chamber for sexual and gender-based violence. So when the International Criminal Court's prosecutor first brought the request asking the pretrial chamber whether deportation falls on this deportation in this case falls under the jurisdiction of the International Criminal Court, the discussion in my circles that are concerned about ensuring that sexual and gender-based violence doesn't get lost in the discussions of all of the other crimes, the discussions in my circles were, okay, so what do we do with the sexual and gender-based violence? Because if the one charge is deportation, where does all of this evidence fit? So initially, we assumed that the evidence fit within the proof of deportation. So the reasons behind the deportation, the push factor out of Myanmar, and that it would be contextual information provided to the International Criminal Court by the prosecutor to explain that expulsion. But interestingly, the pretrial chamber opened some other doors in its findings. So in its September decision, it said that sexual violence could potentially be brought in exactly the same way as part of the context of the expulsion. But it also opened the door, although it didn't link it directly, by saying that persecution is another type of crime that can start in one jurisdiction and be finished in another jurisdiction. And under the International Criminal Court statute, which is the first international criminal statute to do this, gender is listed as a specific ground of the crime against humanity of persecution. So it is possible, the court signaled that it is possible for the prosecutor to bring a charge not only of deportation, but also of persecution, and this could include gender-based persecution, of which sexual violence evidence would be used to prove that particular charge. The court also pointed out that another type of charge that could potentially be brought is under other inhumane acts. And if any of you have been following the development of the international criminal law jurisprudence on sexual and gender-based violence, you know that that particular category has been very helpful in bringing out the range of types of sexualized violence that have happened in conflicts and mass atrocity to extend the discussion beyond rape. So this is another possibility in terms of charges. Okay, so we have the independent mechanism, we have information collection, and we have this potential of the International Criminal Court as a venue for justice. But we know that if something comes before the International Criminal Court, even if somebody is actually physically brought in and there can actually be a trial, even if it's in time, it's only going to be 1 or 2 or 3 people. And there are many others who are also responsible. So let me spend a moment before I end blue skying, thinking about what can we do to fill that gap, because the independent mechanism only collects evidence. It is not actually a full accountability mechanism. It collects evidence to turn over to another body. It will turn things over to the International Criminal Court, but it will have far more evidence that it can provide elsewhere. So what can we do? I think it's important to blue sky and think about what we could do, because it can prompt some ideas in the future when the opportunities present themselves. So one possibility is to create a flexible mechanism, which is mandated to be an international or internationalized or regional criminal tribunal, but which could begin in the form of an office of the prosecutor doing the same sort of work or in tandem with the international mechanism, but then expand when the opportunity presents to charge, arrest, and try an individual or many individuals, and using a roster system like the mechanism for the International Criminal Tribunals or the Residual Special Court for Sierra Leone, have individuals ready to be able to serve as defense counsel, judges, and prosecutors in order to allow this body to come into fruition in a relatively short period of time. And in doing so, we need to ensure that all of the steps in whatever tribunal it might be are taken in a gender-sensitive manner. We have more than 20 years of experience now, often of mistakes, unfortunately, but sometimes of best practices, and how to make a tribunal gender-sensitive from the very beginning. So I'll end by sharing with you some lessons learned from a different tribunal, but one which I think provides a good example of how things could be done in my blue sky tribunal that I'm thinking about. And this is the Special Court for Sierra Leone, which was a small tribunal that was in existence from 2002 until 2013 in the West African country of Sierra Leone. And the reason why I raised this one is because it was extraordinarily successful in prosecuting sexual and gender-based violence, a full range of sexual and gender-based violence, in a way that other tribunals, especially the International Criminal Court, have not succeeded. So, first of all, we would need, the international community, would need to ensure that gender-based violence and sexual violence are discussed at the stage of drafting that statute or that tribunal, the tribunal statute. So we need to think of it from the beginning. Secondly, it was very important in the Special Court for Sierra Leone that the very first chief prosecutor identified gender-sensitive justice as a central mission of that court, and that mission carried through every other chief prosecutor from the beginning until the end. Thirdly, it was very important that excellent sexual and gender-based violence experts were among the very first people that were hired at the Special Court for Sierra Leone, and that they had deep cultural understanding of not only the war in Sierra Leone, but the culture in Sierra Leone and the non-governmental organizations in Sierra Leone working with women and girls, men and boys who were affected by sexual and gender-based violence. Fourthly, the Special Court for Sierra Leone integrated Sierra Leoneans into all levels of the court, which allowed the Sierra Leoneans, male and female, to be deeply integrated into the investigations and prosecutions of sexual and gender-based violence. And they brought that cultural knowledge. They also brought the language, and they were able to help make connections within the Sierra Leonean community to allow for stronger bases of evidence. The registry also had an expert psychologist who was an expert on sexual and gender-based violence and child soldiers, and the rest of the staff were Sierra Leonean, and they worked closely together with the Office of the Prosecutor and the registry and Defense Counsel to ensure that gender-sensitive victim and witness protection occurred throughout the process. It was very important in the Special Court for Sierra Leone that there was an outreach team operating from the very beginning of that court, headed by a gender-sensitive Sierra Leonean woman. And in my Blue Sky Tribunal, we would have a similar type of expertise, local expertise on sexual and gender-based violence, which better allowed in Sierra Leone sexual and gender-based violence to be discussed openly and directly in the town halls, in the outreach actions of the court officials. To end, there is no single answer, obviously, on accountability. However, that accountability, I urge, should be gender sensitive to the sexual and gender-based violence from the very beginning. And I think we have started off well with the United Nations fact-finding mission documenting and non-governmental organizations documenting the sexual and gender-based violence. But the challenge is going to be taking that information, turning it into evidence, and ensuring that actual accountability takes place. Thank you.
Thank you. You three, it was a very complimentary presentation. I think I'm going to leave you the floor in exactly 1 second, and we can have conversations, but and with you. But I think that the Rohingya situation sort of exemplifies the successes or promises of international criminal justice as well as its failures. And if you look at what Kyle has mentioned and the growth of hate speech and how it all built up in front of everybody on the online space, and how we saw it coming, and how Payam said that, again, it's a failure to prevent. It's a missed opportunity to gain some of or to learn from this lesson supposedly learned of the past. But at the same time, Val mentions, and a lot of the speakers spoke about, some of the things that are now, there's no turning back from these evolution of international criminal justice. Accountability is part of the dialogue between most states, and Myanmar must be. And there's discussions, the media talks about it. Sexual violence has been in the media, whereas it has not always been the case. And so we see the challenges, obviously, limitations upon jurisdictions, limitations about capacity, but we see also some of the promises. And one of the promise, I think that's quite recent, is the presence, very early on, despite maybe not early enough, of collection of evidence, and in a proper way in terms of, and we can see that in Syria, and we can see that in different countries where the actual justice, the criminal trial is not quite an option yet, but there's justice steps that are being taken, which is essential. And I think the Rohingya situation shows some of that and how we're moving forward. Thank you. I'm going to leave the floor if you can.